back, y'all. I wanna go over motions today. I probably start. This is gonna be more than one part on this video. So this is gonna be part 1 of 11 types of motions in U.S. law. I found this document. I thought I think it's pretty informative because a lot of people have been taught, including myself, by some of these people on the internet they're teaching you not to use motions. We use affidavits. We don't use motions. And if you go back in my previous videos, you'll see that affidavits are supposed to accompany motions. So anyway, affidavits, yes, that's by living man. We already know that. We've already been over that in our video, in previous videos, and we've looked those things up. So if you understand, they both show motions have different. That's why they're called motions. Motions are documents that are used to move the court, to get some movement in your court case. That's why they're called motions. Affidavits are used to basically, those are like testimonies, sworn testimonies reduced to writing. Okay, sworn under penalty of perjury. They serve two different purposes. Okay, so if you understand what each one of these documents are for, then you'll understand why you can still use motions. You should be using you can use motions inside a court case, but that's up to you if you want to use them or not. That's up to you. So I'm just relaying the information to let you do whatever you want to do with this information. Okay, I'm gonna start by reading this here, and I'm gonna do two of the 11 motions that this document is talking about, and this is where I got this from, so you can look this up. This is what this website is, thelawdictionary.org. That's where I got this from. You can type in 11 types of legal motions and you'll find this document. I know I like to show y'all where I get stuff from instead of just like showing y'all, just saying stuff. And some people give y'all lectures and don't give you any credible sources to look up nothing. So I like to give the sources. Here we go. For a court to get your ass out of the way. For a court to take most actions in an issue that is in dispute, either party in a case must ask the court to decide on that issue. When a plaintiff, prosecutor, or defendant asks the court or judge to rule on a specific issue, that request is known as a motion. Legal motions are one of the most common facets of the American justice system, and they ensure that controversial and disputed issues related to a case can be settled quickly and efficiently so that the case itself can ultimately be resolved in an effective manner. Different motions are used at different points in trial, including while lots of different types of motions, and the hell was this I missed? Before trial begins, during it, and after the verdict has been delivered. While there are lots of different types of motions, of legal motions, the ones below tend to stand out for being both very common and very important to individual cases. So y'all know that there are more than just 11. Okay, we're gonna start with a motion to dismiss. A motion to dismiss is one which is most important, which is most popular, known as throwing out a case, is requested when one side, usually the defendant, contends that the plaintiff's claim is not one on which the court can rule. In other words, when the motion to dismiss happens, the moving party is not contesting the facts that as presented by the other party, but merely saying that the claim at issue is not a legal one on which the court has any say. I should have thought about that when the case was brought against me by my son. I'm like, they ain't got no say so over your kids, for real. So anyway, that's something I should have thought about in the first place. I never knew. See, back then I didn't use motions because I was taught not to use motions. And it's probably why the case drug out from September 2016 all the way to, I think, like June or July is when all the paperwork stopped going back and forth, or that following year. I'm like, that was exhausting, extremely exhausting. And just entertaining the conversation about your kids when it has nothing to do. The courts have no say so. They have no jurisdiction to rule over how you raise your kids. You're supposed to respond to that. But if you don't respond to it, of course they're gonna railroad the hell out of you, because they go with the presumption that they do have control over your stuff, over your private matters. Anyway, back to the document. A motion to dismiss is one of the most important motions to understand in U.S. procedural law. The moving party in such a case may concede that the facts of the case are true, but the case should nonetheless be dismissed because there is no legal issue presented in such facts that the court can rule on. This motion helps ensure that the dispute that involves no legal issue does not end up wasting the court's time and resources. In some cases, there may even be a legal issue at stake, but the statute of limitation has expired, meaning the court has can no longer deliver a verdict. Additionally, a motion to dismiss may be filed if the defendant waives his or her right to a speedy trial, has been granted immunity or pardon, or if the defendant had been previously tried for the same offense, which is known as double jeopardy. That reminds me of that movie called Double Jeopardy. It's a good movie. Side note. Anyway, but a motion to dismiss is, now y'all see, this is when you see there's no standing for them to even bring you to court in the first place. There's no injured party. There's no breach of contract. In a civil case, again, there should be some type of a contract breach of some sort. There's no contract that exists. You know what I'm saying? So why are you there? So motion to dismiss. Throw this shit out. There's no injured party. There's no breach of a contract in a civil case. If it is a criminal matter, there's no injured party there. Anyway, discovery motions. During the discovery process, both parties to a lawsuit or a case will collect information and evidence that they can then use to build their case. The discovery process, like its name suggests, is the prosecution and defense. Is when the prosecution and the defense makes effort to discover all the facts of the case. Both parties can request information from the other to help establish the facts of the case. A number of different motions can be used to ensure that both sides are able to handle the discovery process to the best of their abilities. If the other party fails to respond to a request for information, for example, when a motion to compel discovery of that information could force that party to provide a response. Another motion to compel discovery could be used if the party responds to the request for the information, but its response is vague and incomplete. Failing to comply with either motion could result in the offending party being held in contempt. So this is one way I was talking to a buddy of mine recently, where he's dealing with a case where there's a proclaimed injured party, and I'm letting him know this is I was in a three-way conversation, and the other party who was in the conversation advised him to do a motion for discovery, which was excellent advice for him, and I co-signed on it because he don't know exactly what evidence is being used in this case that's brought against him. So this is what he needs to be using, and so this is a good move. So say if you're a defendant or there's someone claiming that you injured them some type of way, this is the first thing you want to do is gather up all the evidence, make them prove it. Make them prove it. I used to be like filing what did I say? Basically, I used to use a different set of words, but I didn't say motion to discover. I used to say something like proof of claim or something like that. That's what I used to use, those types of words. But this is actually the words that they actually use. They don't say, requesting proof of claim or nothing like that. They will be like, it's a motion for discoveries. That's exactly what this is. So I'm gonna go one more because I got stuff I got to get done today. I'm a caregiver, y'all, so I got to take care of my Papa Bear. So I'm gonna finish this part right here, and I'm gonna go with part 2 later on this afternoon. Motion to compel. When making a motion to compel, the moving party is asking the judge to use the power of the court to essentially force another party to do something that he or she has so far refused to do. As noted above, motions to compel can be used during the discovery process to ensure that both parties have full access to the facts of the case. For example, if a plaintiff refuses to answer questions in a deposition, the defendant may file a motion to compel to the plaintiff to answer those questions. If that motion is granted and the plaintiff still refuses to answer the questions, then he or she may face contempt of court charges. Of course, motions to compel can also be used when a trial gets underway, such as if a witness refuses to answer a question while testifying, and they are not limited solely to the discovery process. Okay, so I'm gonna stop right there for now, y'all. But y'all see, this is what I remember when I was dealing with my child support case. There was what was it, like a interrogatories request, some type of motion for interrogatories. I forgot how it was named, where they were trying to get me to answer a series of questions like where I know the place of work, how much money I make, all this different stuff like that. They're trying to get financial information from me, and I responded in writing. Of course, I didn't consent, and I received a motion to compel after that. It was like a motion to compel. It was actually a motion to compel first. It ended up in a hearing, and some type of way I think they filed after the hearing. The hearing. I repeatedly made it clear that I didn't consent. I wouldn't even let them call me Mr. Roseman. So I was on some amateur shit, but it still worked. So the thing was, I ended up receiving an order to compel. It was like an order to compel. That's what it was called. An order to compel is what it was. And they were trying to force me. To compel means to force someone. Okay? That's what it means to compel. I'm gonna shut it down after I show y'all what I'm talking about. Get your ass out of here. How the hell I get that? Okay. To cause to do or occur by overwhelming pressure, and especially by authority or law. Cannot the defendant to testify. Anyway, basically that's what it means in blue right there. They basically force somebody to do it, to put some pressure on them, and that's exactly what they did in the hearing. They tried to force me to do the shit. You can't force me to give you shit, and I didn't give it to them. I still responded again in writing. I even started quoting the Constitution at that point. So anyway, that's how they stopped with the pressure, because I just kept on. They couldn't get me to comply. So I'm gonna say that's exactly what made them stop. Because they know they couldn't make me give them shit. It didn't matter what kind of pressure they would do, because this wasn't a criminal case. It was a civil case. It was a child support case. Where they're trying to force me to a child support contract. Like, I'm not trying to be involved in that shit. I don't consent to it. So I'm not gonna give you information so you can put me into it. So that's why I didn't. I kept responding. I just responded to everything, every piece of paper I got. But anyway, I don't want to drag this out. We are about 15 minutes into the video. I think I did pretty well. Y'all know I be running these videos kind of long. I'll be I'll be covering maybe probably 2 or 3 more of these this afternoon. So y'all expect more. So I'm gonna finish this document. It's a pretty good one. So I'll see y'all in the next video. If you haven't already subscribed, go ahead and do so, and make sure you like to help me out with the algorithm. And we will keep going. And I'll see y'all in the next video. Emerald signing out.